We'll call this workshop of February 15th, 2021 to order. We have one item on the agenda, conducting a joint workshop with the Planning and Zoning Board to review and discuss the Traffic Impact Analysis TIA Ordinance. We are joined not only by members of the Planning Board, but also by Kimley Horn in person, as well as John Torbett and NCDOT via WebEx. So if you have any further remarks, Adrian, before we get going?
So just as information, I think all of you have had meetings in this room, but the restrooms are through those double doors. Looks like everybody is keeping their social distance and wearing their masks, so thank you for doing that. And it looks like you're all wearing it properly. We'll have these on for the entire meeting. If you need to get up for whatever reason, we do have coffee and water behind Shelley. But if you need to get up, this is informal. It's a workshop, so help yourself. If you need to take a call, you're welcome to step outside. Representative Torbett, thank you for joining us.
Pleasure being here.
Yes, sir. Thank you. And we have our friends from NCDOT as well, remotely. So if there are no questions on kind of the format, we'll have just a brief overview of the TIA ordinance, and then I know the Planning Board had requested a discussion about the TIA ordinance and kind of how it's been implemented. Is it working how it was intended? So we'll have an opportunity to discuss that. We'll have the experts either in the room or via WebEx. So hopefully all your questions will be answered, and then we'll figure out if we need to make any changes going forward. So I'd like to start just giving a little overview of where we are and kind of some growth pressures that we have. Shelley will talk about the TIA ordinance, and then Brady with Kimley Horn will talk about some of the examples that we've had. And then Parks will get into some of the legal structure surrounding transportation ordinances and transportation impact ordinances and some recent case law from our region. And then we'll just open it up for discussion. Does that sound okay, Mr. Mayor Pro Tem?
That's wonderful.
Thank you. Again, we want to open up all of our meetings with our vision statement, which is that Belmont will be a vibrant, multi-generational community that incorporates small-town charm and heritage with an entrepreneurial spirit. We've already gone over some of these guests. Representative Dana Bumgardner was hoping to join us. Something came up last minute, and he doesn't appear that he's going to be able to join us. And Senator Harrington also was not available to join us, but she did want to get a copy of everything that we're discussing today. So we'll make sure that Senator Harrington and Representative Bumgardner and Representative Torbett get a copy of all of this information. We do have Blake Guffey from NCDOT, but also Mark Stafford. Blake and Mark are from Division 12 out of the Shelby office, and Mike Reese, who is, I believe, is with Congestion Management at the central office in Raleigh. So we have the experts from the state with us today. So thank you all for taking time out of your schedule to join us for this workshop. So we all hear about traffic in Belmont, and traffic in Belmont is a real issue for all of us who live in Belmont. But I wanted to kind of set the stage for where we are relative to our region. And having traffic problems is a problem, but it's a sign that we're in a growing region. Kevin and I were at the State City Managers Association conference virtually 2 weeks ago, and one of the presentations was about an economic forecast for this year and next year. And this is either good news or bad news, depending on your perspective, but we are in the third largest economic region in the country. So the Boston to New York region is the biggest economic engine in the country, followed by Pittsburgh to Chicago, or Chicago to Pittsburgh, depending on your perspective. Ryan, but you can have Pittsburgh first if you want. And then what they call the Charlanta region, which is Charlotte to Atlanta, but really stretches from Raleigh to Birmingham, Alabama, is the third largest region in the country in terms of economic development, economic output. So I mean, you all know all this. People are moving to the southeast, they're moving to our area. I-85 is the corridor that connects the Charlanta region. We're producing jobs, we're recruiting companies, we're starting companies throughout the Alabama, Georgia, and Carolinas region. All those states are vying for new jobs, new growth, new people moving here. And Belmont is in the middle of all of that. And we're a very, very, very small piece of a very large, robust region. So just keep that in mind. We can talk about what we can control, but a lot of the region is outside of our control. So just remember that when we make these decisions. Also, think about where Belmont's located within our immediate region. We see the traffic on South Point Road. We see the traffic on 85. We see the traffic on Wilson Boulevard. A lot of that are people not from Belmont driving through Belmont to get to their destination, whether that's the job centers in Charlotte and Gastonia, whether that's recreation on Lake Wiley, whether that's going out to eat in Stanley or Mount Holly. People are driving north, south, east, and west through Belmont. So we really cannot control traffic through Belmont. What we really need to focus on is traffic from Belmont. So, a car on the road or a truck on the road is a car on the road and a truck on the road. And it doesn't matter if they're living in Lake Wiley or Mount Holly or Gastonia or Charlotte or Belmont. If they're driving through here, we feel it. That spurs economic development. That's why we have the commercial base that we have, which is pretty big for a town of 12,000. But it's also why we have traffic problems at certain times of the day. But again, we can't control the traffic through Belmont. We really can only help to mitigate the traffic from Belmont. And that's what we'll talk about in the next section. So just to give you data, and none of this is good or bad. This is just information. This is the change in population in Belmont over the past decade, according to the North Carolina Office of Management and Budget, State Demographer's Office. You see we've grown. In the 2010, we were at 10,145 people. We're now 12,123 as of the estimate from July 1st of 2019. And hopefully we'll get our 2020 numbers at some point. It keeps getting delayed, but hopefully we'll get 2020 figures at some point. So we've added about 2,000 people in 10 years. So if you look at an annual population change, we kind of peaked in 2012, between 2011 and 2012 at 4.5%, but it's been closer to 2-3% since then. Again, adding a couple hundred residents in Belmont city limits each year. And we talked about this in one of our workshops last year, but I think it's good just to remind us of kind of what our growth is relative to some of our neighbors. Within Gaston County, we're one of the fastest growing towns, second only to Cramerton over the last decade. But putting us kind of around the rest of the Charlotte region, we're kind of in the middle, lower middle part of growth over the last decade within the Charlotte region. And you see Harrisburg and Waxhaw have more than doubled our growth rate over the last decade. And that's just the Charlotte region. So if you were to put Belmont in the Raleigh the Triangle region, you see we would be among the slowest growing towns within the Raleigh region. So as much growth as we've experienced, it's not as much as other towns within the Charlotte region. And even that's not as much as other towns within the Raleigh region. So again, we are in a growing area. So again, this kind of talk about the growth from Belmont versus the growth through Belmont. So with that, talking about what we can control, I'll turn this over to our planning director, Shelley DeHart, to talk about the TIA ordinance.
Traffic consultant. Now, we weren't the first small MOU, and then provide that to all parties to sign off before we begin the TIA. Then that kicks off the TIA phase. We will perform the TIA based off of the MOU, and then provide that to the city and NCDOT for review and approval. And depending on the complexity of the study, we'll typically have 1 or 2 follow-up meetings to kind of discuss the findings of the TIA with the applicant, with NCDOT and with the city, and if GCL MPO is involved. And then from there, sort of kicks off the post-TIA process. So the TIA will get approved in its form. So from the traffic, the technical components of it, which will identify the mitigation. And then from there, we will work with the city, depending on what the improvements look like. Sometimes we are available to develop concepts which can determine the feasibility of improvements before they move forward, or are there right-of-way issues, things like that, and then we'll go from there to planning board and to council to finalize the requirements of the site, the transportation requirements of the site. The applicant does. Yep. And then from there, to wrap everything up from the transportation side, per the ordinance, all transportation improvements or payment in lieu are required to be provided and or installed prior to issuance of the CO, the first CO.
Any questions?
Do you think, I think you've asked this question before, some of these daily trip counts and everything, what effect do you think the pandemic might be having on maybe speeding those forward and might have
In general, the traffic counts or the traffic counts we use for the TIAs?
Well, I guess both. I'm assuming that some of the ones we've been using recently might have been conducted before the pandemic started, but eventually that's not going to be the case for some newer projects. So I guess it would be both.
Yes, it's a great question. I believe, and I'm not going to leave this, I think we've used, for the most part, all of our TIAs up until this point. We have not collected any counts to be used with it since, I guess, March of last year. I believe going forward, depending on how things look from a traffic standpoint, what we've seen is a mixture of, all right, we have some good data. The good thing is a lot of developments occurred in Belmont since 2017. We've done a number of TIAs that included most of, if not all of the primary intersections within the city. So we have a good database of accounts, as well as NCDOT has a very good database of accounts as well. And then we have some other traffic vendor partners that we can reach out to that we can, they've been nice enough to sort of open up their database accounts that we can reach out to them. So we have a pretty good overview or a pretty good range of sources that we pull accounts from. As we move forward and we need updated accounts because of the pace of growth that we've seen in Belmont, what we can do is, if there is an intersection where we don't have an account, or maybe it's too old, if we do have a nearby intersection, we can count that intersection and sort of compare what we would call the COVID factor is to determine how much the traffic has been brought down or up, and then increase those to a certain level. The important thing to point out from a TIA standpoint is it is important to collect realistic counts. But one of the most important things to understand is that we're really determining the impact of the proposed development. So whether the background traffic is at this level or this level, we're still going to be measuring the impact of the development and then identifying the appropriate mitigations for that. So we tried our best to get the most realistic counts, but COVID hasn't helped in that manner. And I would assume this is
going to be subject of further discussion, but when you're doing that, you also are take into account other developments that might have been approved but not started yet. So if we're looking at the TIA for the new recreation center, and we're looking at the intersection, say, of Chicago and Wilkinson, we have to count the fact that, Aberfoyle is going to be all filled out, even, when that wasn't the case, and take that into account. And we have to take the Morris and the fact that that's going to be built, and all the traffic, whatever those figures are.
Yes, absolutely. So part of our scoping meeting is we talk about the approved developments to include. So those approved developments is we will take the traffic that is projected for those developments and add it to the counts that we have. And so in this time where we are leaning on older counts sometimes, we are being very intentional about making sure that we understand where those counts are from. And so that maybe there's a development that just recently got constructed. We want to make sure that the counts reflect that development. If it doesn't, we'll add that as an approved development still, even though it was recently constructed, make sure the counts accurately reflect those.
What kind of pushback do you get from the developers?
From the data, in terms of, as it relates to COVID, as it relates to COVID, in general, we get, developers will ask questions, and, you get a wide range of responses.
I'm sorry, repeat that. Well, the way our TIA policy reads is that the city hires the traffic engineers to prepare the study. Kimley Horn works for the city. And we have them working for us because we know that sometimes
developers have their own favorite traffic engineer that may model something differently and get a different outcome. Now, we've only had one case in where a development team has come back to the city, requested to let them hire their third party to analyze what our traffic engineer has prepared and then give us feedback, but then they have to pay our traffic engineer to analyze what their traffic engineer does. So they want to go that route, we can. It's fun in that project again. Henry's Chapel, evaluate.
Analysis or recommendation or well.
Yeah, the TI reports themselves are
So it's ultimately council decides.
That's correct. So Kimley Horn is at both their information. Again, just so you know, it is also coordinated that state maintain. So that's part of the project. But when we bring the project forward, focus recommendation that everything forward and try to possible problems or storage that is right next to cemeteries that don't meet the need. So we do evaluate things, try to do that before the and all the information.
Like I said, the scoping meeting, all I have as far as mitigation.
yeah, and the scoping meeting is a little early on in what the mitigation will be. We discussed what the intersections will be studied, and then the whether or not we're going to use a certain software package, depending on what type of intersection, they look at the roundabout versus signal, we have different software package. Some of those technical details. We don't know what the mitigation be for it intersects or intersects with mitigation yet that early on.
Is there a limit of sample analysis of the assuming households is swallowed?
Oh, yes.
But from there, is it comfortable? So is there a limitation from that? So then, just kind of take it longer.
No, so typically, let's say you have impacts that are determined, and the ordinance kind of lays out which intersection and what level of impact requires mitigation. So there's really not a whole lot when you actually zoom into the intersection. Drainage improvements. So we'll kind of test out what makes sense. Looking at which have higher volume, doesn't have a turn lane, which movements. The right turn lane is the lowest hanging fruit. Of course, they don't have right turn lanes, so we ask them by doing that before we get to actually approve that. So we'll kind of test out some of those. From a scoping standpoint, those are all the things we do. I would say our limit of mitigation is kind of dictated on how many intersections we have.
Really, just fairly standard process. So it's not like, my phone was just the finish shot. Your recommendation when you start with the floor.
Oh, right now, Steve, I think you heard this, but I recall, I think we kind of laid out, this is a stretch,
Corridor
that
it's already
heavily
heavily traveled.
traveled.
We're looking at, I think, 600 single family homes, family homes residential is typically a land use that generates traffic that is, everyone's sort of going out at the same time and everyone's coming in at the same time, and you're in a location on the southern or midpoint of a peninsula where probably 90% of the traffic's going north. So you're probably going to have some mitigation. But we didn't know what that was going to look like at the time, at the scoping meeting. Yeah, so I'm not sure if I answered your question. Sure. Yeah, so we started out with, after the scoping meeting, we kind of scope how much is going to go into the TIA and which intersections, whatnot. We will then develop the fee, and that's a standard fee. And then, if it goes beyond the typical process, which like Henry Chapel does, then we'll work out, payment and the fee scope after that, which is we review the applicant's third-party review.
Hey, Jim, we have Representative Corbett. What are we trying to accomplish today? Are we just trying to get up to speed and on the same page?
I think there were some questions, and I think the members of the planning board can fill in some of the details, but I know that there were some questions at the last meeting just about the TIA and how it all works, looking, I think, at the cumulative effects. Are we just, if we keep doing things piecemeal, are we missing the fact that everything incrementally adds up to a whole lot more? And I think there were some questions about how effective is the TIA. I certainly have one question for Representative Corbett, but I think that ties in with what Parks is going to present on some of the legal aspects of it and whether we can get any sort of legislation from the General Assembly, because as I understand it, Parks is going to talk about off-site impacts and what power you have, we have as a city over that. And my understanding from some of the cases I've looked at is you can get special legislation from the General Assembly that might allow you to do what otherwise you can't. And so, I thought that might be a possibility given the uniqueness of the peninsula and the issues with South Point Road. And I don't know if there's any other thoughts, but that was how I understood some of this. Well, then does it make sense to turn to parks and
So
have
that's a
Jim-
good segue. We were going to go
Yeah,
into.
we were just,
Thank you. We were going to go into asking the city attorney
so, yes.
about our legal authority to do all of this.
Okay, this is,
Yes.
this is gonna be a little confusing, but,
This is the best part.
so be it.
More lawyers.
So we've had, for most of our, projects have been, particularly the larger ones, have fronted on state roads, and we've made a condition of the zoning approval that they comply with all DOT requirements. That's been one standard, and we've done pretty well with that. Second bullet, Shelley's a pretty good negotiator, so she's been able to use the conditional zoning process to get the developers to agree to things in exchange for maybe some kind of concession for some of our ordinance provisions that they wouldn't otherwise agree to. But when you come back around to our authority to require off-site street and transportation improvements, this is where it gets, we're limited. The Buckland case is the Court of Appeals case that's cited most often, and it is cited for the reason that a municipality subdivision ordinance where we're trying to grant a development approval and people subdivide their property may require a developer to consider existing or planned streets when it plats streets and highways within its subdivision. So within the subdivision is the key, that we can require that within the subdivision. But the statute does not empower municipalities to require a developer to build streets or highways outside a subdivision. So we hadn't really been too, and the court case went on to say, if you're requiring any of that, you may be able to get in a conversation with the developer about paying in lieu fees, which we've done. And she cited the examples. So similarly, the DOT's standard position about requiring off-site improvements, probably you guys can tell me if this is accurate or not. Developers have, in court cases, have seen to acknowledge that they can require certain off-site improvements like acceleration and deceleration lanes, traffic storage lanes, or medians located near where the proposed development will tie into their state system. Municipalities don't really have any authority to go outside the state, the proposed development, and we're authorized to seek from the developer a financial contribution to help with those off-side roadway improvements that's proportionate to the impact. And that's when you get into an argument about, well, that's unreasonable, that's not proportionate. Building a 4-lane divided highway for a half mile for a 600 unit subdivision is not proportionate. That'd be their argument. So you get into that, and we've sort of just been able to come out, pretty well so far with this system without being challenged. Now, the bigger subdivisions that y'all gonna start seeing, I think, and the bigger price tag with off-site improvements is going to probably present some pushback. So we've got the Buckland case,
Which is the Court of Appeals.
which is a Court of Appeals case. Last year in February, Mooresville was challenged by a developer where they as a result of their traffic impact analysis ordinance, they actually entered into a written agreement with the developer for mitigation of off-site street and transportation improvements where the developer was required to do certain things and make these improvements. And they got into it and did some of those. But as they progressed, and I only got this today, so I'm not clear on details. But as they progressed, they became unable to complete the roadway improvements, so they went to court and said, Judge, they don't have the power to make us do that, even though we've signed this agreement saying we will. And that was in February in 2020. In August, a Superior Court judge in Iredell County sided with the developer, citing the Buckland case, and said, Mooresville, you don't have the authority to require this. Plus, I as a judge am going to issue what's called a mandamus, a written mandamus requiring you to approve their development, even though they're not going to build these, they're not going to finish building the roadway improvement. That was in August. It's on appeal. So that drags out. It's a mess right now with COVID and all that stuff. Courts are slow. So I don't know when that'll be heard, but that's out there. And that kind of thinking has not been, or that kind of reasoning and has not been friendly to municipalities. So what do we do with that? Well, one thing, we just keep on doing what we've been doing. It's one avenue. Another is we may be expected to see a challenge, particularly on larger projects. Continue to collect the pay in lieu when it's appropriate. And then there's some talk about, I know Councilman Seelinger at the retreat mentioned local legislation, potential to ask for some traffic impact fee authorization, as was done in Wake County back in some time ago. And so that's part of this dialogue today, and particularly with Mr. Torbett. And I, Mark Stafford or whoever's from DOT, if y'all want to jump in and respond to this about, I know you're aware of the Mooresville case and the other things that have generally caused us a little bit of angst about these things. Would y'all like to comment about it?
This is Mark Stafford. Can you hear me?
Yes.
If we don't have the right-of-way necessary, we can't require them to purchase that off-site, and therefore, even if they agree to it, they can't. So that's where we run into those issues as well. And I will say that we've done pretty well throughout, at least in Division 12, with some fairly large developments, and I know the development push that y'all have there is putting a strain, and obviously that's the impetus for the meeting today. So we concur with the same issues that you're seeing there is kind of what we're seeing all over when it comes to a growing state that's adding more trips and areas that are looking to develop.
And to me, obviously the most troubling thing is that, the case that Parks just mentioned from Mooresville, they entered into an agreement. So you could say, well, you can't make them, but they agreed to it. And then they said, well, it's too hard for us to complete the agreement, and the court let them out of it. And that's troubling.
I guess the question then would be to Representative Torbett, if there is something that can be done legislatively. I've seen there's been a slew of cases filed in Wake County challenging impact fees, usually recreation fees, that say that the municipalities, instead of, you may require them, they're saying, but you're in fact always requiring them, and they're not proportional, and you're not charging them in connection with the impact that you're having on the subdivision you're building. They're assessing them out of proportion. And one of the things that's always alleged in those complaints is, and there's no special authority given to this jurisdiction by the North Carolina General Assembly. So, there seems to be some way in which the General Assembly might be able to step in here, and maybe this is an appropriate case to help us with local legislation, given the impacts of development and the unique sort of situation on the peninsula. So I don't know if that's something that's done or what, but I guess that would be my question to you, Representative Torbett.
Is this my time to chime in?
Yes, sir.
Hey guys, thank y'all. It's good to see you. Hey, on the impact fees, that's a lot of water. I don't know if I can carry that much. A lot of my colleagues up here, if you remember, dispelled that some years back. But I am interested very much about the mutually determined agreement between the municipality and the developer. There may be some wiggle room where I can tighten stuff up on there, because, once you enter an agreement, short of you going bankrupt, I think you need to meet your agreements. So maybe there's something I can do there. I'm not the attorney. You have a great one in the room there tonight. But if you can pin me something, send me some bullet pointed concerns, I'd be more than happy to try to flush those out up here and see what we can do.
John, on that, recognizing the courts will probably, on Court of Appeals will probably deal with that contract issue, but specifically for your colleagues in the legislature, are you seeing any municipality or other jurisdictions asking for transportation impact fee authorization?
I have not heard that as of yet. Let me tell you what I am hearing, though, just to keep y'all totally abreast what's going on. As y'all probably know, some years ago, I passed a law saying that for school road improvements, those would be done by DOT. Unfortunately, that also means that if a school is going to be in a municipality, those will be done by the municipality for that school. When I got that one passed, the developers came to me and said, well, won't we do the same for developments? And I said, that's just a little bit of bridge too far right now. We have to figure out a good working relationship so developers can develop and municipals can not have artery clog, which is what we were operating under for about 20 years. As we bring in thousands upon thousands of homes, we weren't building sufficient enough throughways to carry people to work, back to work, which is kind of like we're trying to climb out of now. So now we're working with pretty much telling developers that, yes, you can build up here, but you have to do the following improvements. I think that's a good path to be on. I think the mutual agreed upon is the best outcome. We just need to make sure that we have those discussions like you guys have, and then pin them on paper, sign them, and stick to them. And I'm thinking, like I say, that to me seems to be the best foot forward. Just need to get in and dig around the law a little bit, see how we can strengthen that up a bit.
Hey, John, or Representative Torbett, Ryan, hope you're doing well.
I don't know much about what you do there, but over the past few years here, it seems like every effort that we make to move forward to get some sort of leverage over a new development, that the state changes legislation removing our authority in that way. And so I know that North Carolina is a very pro-growth state, and kudos as we've broken records over the last decade. But I mean, we are in a different time today where local government has little to no authority, whether it be around architectural guidelines, whether it be around controlling what can happen here or there. This was what I thought was a very good solution, where it would be, here's the traffic. You don't have to go above and beyond, but all you have to do is bring it right back to the same level of where it was. And I mean, mutually agreed upon is far-fetched in a lot of ways when it's us and the developer, because I mean, within 30 days, they just threaten lawsuits, and they just jam that stuff down your throat, and they have attorneys and lobbyists, and we don't have any of that. We have a good local attorney, and he tells us what's best, but, I mean, they just step all over us, and it's pretty consistent there. I think what we really need is just to have the authority to just say, hey, you know, we live in a small town, you want to triple our growth, how about put some roads here? And we need the state to come in and say, that's okay for us to do that. And I know that's a big discussion, threw a lot at you there, but we.
Great. I look forward to hearing that. But send me something on paper that I can call my legal team in, and we can sit down and discuss and see if we can't tighten some of that, make it easier for y'all to work, make it easier for developers to work. I would say that common sense is the prevalent operating procedure up here, but I'd be telling you an unfactual statement. Unfortunately, oftentimes more than not, and I'm sure council can tell you the same, is that if you have a bad actor that kind of ruins it for everybody, then General Assembly steps in, and for the sake of all good for everyone, they set a law in place that goes way too far. That's what happened when the impact fees, aesthetic look on the property that was altered a couple of years ago. All that came from maybe one or two bad actors somewhere else in the state, not Belmont by any means, that just raised that alarm. And once you lose it, it's really, really, really hard to claw back. But there are ways to do it, and I think the best way to do it is just work from the collaborative way. But if you can send me those difficulties you're having with developers, and if you can phrase that and send that to me, I'd be more than happy to, I guess, bring that to their attention when they're in here. So that I can pledge you, I'd be more than happy to work on. Richard, honestly, and let me flush them out and see if I can get any yardage with any of them, and make just get things to stick, I guess, is what's the most difficult thing up here. But it's not that difficult when you're working with good people. I know Mark over at DOT, he does a great job as well. DOT, I have a lot of friends and colleagues there. We're all after the same thing. It's just the easier and more economical flow of goods and services and people from point A to point B. It's unfortunate that my personal belief is that we went for several years without the severe focus and priority set on keeping our neighborhoods unclogged. And Belmont is the, it's the dictionary example of what happens when you don't focus on infrastructure as you need to. And until we get some other inlets and outlets going through that area, I think we will continue to just work with what we have, and that's not a whole lot right now. I mean, you got a lot of 2-lane roads going to a lot of tremendous houses, not to mention the one that are on the books to be, coming out of the ground shortly. We have to take that. We have to register that. We also have to take it to the local MPO and beat the drum and get things moved up on prioritization and get things active. But send me a list of those things. Let me see what I can flush out, and we'll start. Just I guess the best thing, build a plan and move ahead. I was able to, I think, work with Adrian was saying had some concerns about one of the major intersections right there. I think it's the Abbey intersection, 74. I was able to go to DOT and get some of that kicked into the widening 85 design, because it literally impacted just across the interstate in the industrial park what's going in there now, and the impact it would have had actually on the intersection there that had already been pre-planned without the knowledge of that industry. So we were able to get DOT to slow down, look at that again because of the added freight traffic. So that we can do those things. We just got to make sure that we're doing exactly like you guys want. Send me have a plan in place, and then if you have ideas that I may not know, especially legal ones, send them to me and let me flush them out with my team up here and see what we can get done.
So it sounds like maybe maybe Parks would recommend some language or suggestions to Representative Corbett about things that we would.
Question.
Sorry, this is Mark Seelinger.
Hey, Mark.
Hello. So I was just asking if perhaps as a way forward, maybe if Parks would be able to suggest some legal language that would protect our ability to basically continue doing what happened, because I feel like of all of our
Not on our state. That's knowledge you guys have that I don't have. But if you can pin that down to like a bullet points or just suggestive paragraphs and shoot them up to me, then that's what I'm talking about having in my hand to reach. And it could be a broad spectrum of ideas or thought processes.
I can work with Parks.
This sounds pretty staff
level technical in my mind with Parks and Sally and Adrian. Do you have fairly clear direction at this point of what we're trying to accomplish?
Yeah, I mean, the goal is to continue to allow moderate growth with off-site traffic improvements that are paid for by the developer to mitigate the impact that their development's having, while working with the MPO and DOT on the bigger picture transportation issues through the spot office and everything else. So we can send some information on that.
Anything can be challenged. You can have the soundest legal argument you want, and you can still find someone to challenge it. But, I'd prefer to win that challenge.
So far, these decisions would just address the traffic, off-site traffic and then transportation.
wonder if it should be two separate subjects as we're approving. I don't know if I guess it can't be unconditional.
No, it really has to
We,
be under the
it seems like we have no course of, like, clawing back anything in our position where they
Well,
can
they're
walk
clawing back.
They can walk away and
Yeah.
do whatever they want, but we can't, like, stop. And I know the impact fees are water under the bridge, but they're not. I mean, they're still alive and well in Belmont, and you know,
And here
it's
again, this
hurting our
Mooresville
community.
case is just one judge has made this ruling. It's disturbing to municipalities, but it is on appeal, so we may get they're overturned, you know.
And I mean,
frequently.
ultimately, you need a Supreme Court case. I mean, even Buckland's just a Court of Appeals case. That's not, I mean, it's more, it's binding on the lower courts, but it's not the final authority until the Supreme Court rules.
But typically, what they're looking for is some kind of authority in the form of a special legislation or local bill, and there may be some jurisdictions that are going to send up impact fee for transportation requests for local legislation. But John, you're not familiar with that at this point.
I have not heard of it as yet. It is early on in the session, but I have not heard of that as well.
And
Yes. Right. Correct.
In theory, yes.
So far.
For discussion, but you know, all I'm hearing now is how can we legally require
I can speak, well, to a little bit of the payment in lieu, because I've seen cases that have recently been filed in that regard. Again, these are all in Wake County, and they've just been filed. They haven't even reached any sort of summary judgment or anything. But, you know, I've seen fees in lieu being challenged now, too. And what you have to be careful of with, and I think originally, you know, and I've served on the planning board with some of you all, we were nervous about fees in lieu because, at least from my perspective, it just seemed like, well, they don't want to do something that's difficult, so here, you know, here's just a check, whatever, who cares whether it really will solve anything or not, but here's just some, you know, it's just a drop in the bucket to us. Here's a check, now we can go do what we want to do instead of having to do something we didn't want to do. And I think that that's, at least from my perspective, why I was never a huge fan of that. I'd rather, if you know, a TIA says something needs to be done, I'd rather them just do it, because if we start allowing too many fees in lieu, it's just like, all right, well, I can write a $50,000 check, and who knows if that'll do anything for that intersection. Yeah. Now, where you also get in trouble is what the developers are saying in these recent slew of cases in Wake County is, and Parks highlighted this, the statute says may require a fee in lieu. And the developers were arguing every single time someone came to you with a development, you charged fees in lieu. And that's not may, that's a requirement. And oh, by the way, it wasn't proportionate because the formula that you calculated had no correlation to like the tax value of the property before the land was subdivided, which I guess is supposed to be the formula or whatever. So you were you were requiring it instead of permitting it. I forget what they, it was an impermissible, mandatory fee, and you were charging too much. Like it should have been X, but you were charging us way up here because you were just arbitrarily setting the fee in order to, get all sorts of money from us, and, the fees that you charged had no relation to whatever impact we were actually having in the subdivision or in the immediate area. And, there are some other things that I think it's easy to avoid, like, when you were commingling the recreation fees and the general fund, and so no one can tell whether, our money actually went to recreation or not. Well, yes, I mean, it's clearly easy enough to button it up somewhat. But,
Excuse me, can I ask something?
yeah.
So the planners work directly with the developers in Kimley Horn as well when we were discussing mitigation. And what we find is it's not that I don't want everyone to think that people are just wanting to pay money, developers just want to pay money to get out of anything. That's not the case. In most cases, they are concerned about being held to their project being dependent upon third parties selling them right of way. And there is no way for someone, the city can't force someone to sell their property and so forth. So they are worried about being held hostage
Well, and we saw
on their
that with
project
Chronicle.
for property acquisition. So they'll look to the city, and we've been asked, will the city help us acquire the property? They would pay the attorney's fee and pay for the property acquisition, or even NCDOT. Does NCDOT have the authority to help us get the right-of-way? Again, we'll pay attorney's fees and for the property, but a private developer doesn't have any authority, and I believe nor does the city or NCDOT, to get the property, and that's what the concern is. They're willing to do the improvements and pay for the additional property, pay legal to acquire the property. There's just no mechanism for them to get that, and that's, most of them will say, oh, I'll do the improvements, but within the existing right-of-way, because then they're not dependent, their project isn't dependent on a third party. So that is part of it. So the two cases that we've had for mitigation, we made the Chronicle developer, for example, give us verification that that property owner will not sell that property before we even entertain accepting the inland fee. Now, I think our ordinance definitely, our TIA ordinance, could be strengthened in that area by adopting a formula. And some formulas were shared with me today where they even do, if we take in lieu fee, they might put, it should cover property acquisition, engineering for the improvement, the construction of the improvement, and then maybe a growth factor of a certain percentage. So if we're going to hold this money, it's going to grow. We'll collect that extra. So if it's not able to be used for 10 years from now, we at least have a little cushion in there. So our ordinance definitely can be strengthened in that area. It does not have a formula in it. We just depend on the engineers, the team's engineers submitting something. That's correct. There's a threshold of 1,000 average daily trips or 100 peak hours. That's either morning or afternoon.
And DOT's 3,000.
DOT's is 3,000 average daily trips. Ours is a third of it. Yep. it's not quite that low.
No, it's the same.
Mhm. Right. Well, and the only thing I'm going to add to that, I agree with you. We have our draft ordinance, or excuse me, our ordinance, not a draft, has flexibility for, even if it comes in under the threshold, to require the traffic study. And for that particular project, we consider using that, but we recognize we're in COVID timeline. We had a TIA that was done with counts pre-COVID, and right across the street that examined every subdivision and intersection that that project would have had to account for, and it was very recent. So we used that instead of requiring the developer to do something that we have all the information in our hands. We used that, and we coordinated with our traffic engineer and NCDOT to evaluate that project based on a current TIA that was done. So we do have flexibility. Again, if a project comes in, if it was further down on the peninsula, we probably would have required a traffic study, and we would have looked for current counts from our other TIAs. But again, this one was just done in 2018. And right across the street, examined the same subdivision. It accounted for the school traffic as well. So it was a good source of data. No, we did require mitigation of identified in the Belmont Middle School. There was first, they had to do a left turn lane, which was outside of their property. On southbound, South Point Road, they had to do a left turn lane with 100 feet of storage, if I'm correct about that. Smith Farm. Yeah, so they had to do an improvement on South Point Road, and again, it was coordinated with NCDOT and our consultant, as well as we asked them to do the outstanding traffic improvement tying into the adjacent development as well. We told them they had to have their access into their community at that signal. They provided 2 points of access. It's when they do the improvement, dedicate future right-of-way. So if the future widening comes in, that right-of-way was already dedicated to NCDOT and the left turn lane. So there were off-site improvements required. Yeah, we could definitely look at that. Yes, that is something we can look at, yes. Correct. No, our ordinance says they need to reserve it. If it goes through their site, they're supposed to actually build that improvement. But no, there's no requirement to dedicate to NCDOT. Yes, yeah. So we look at it every time there's a project. We look at the CPP or the thoroughfare plan and require dedication.
The discussion, and part you can probably aid and assist is that one, have y'all contemplated some form of TIF? And the second one is, have you thought about using bonding as a tool?
How do you mean bonding as a tool?
Like for a developer, in order for him to do his development, he agrees to whatever on the road improvements, and then he sets aside the dollars necessary through insurance or whatever that would provide funding for that project should he decide not to provide funding for that project. I know, for example, in Rutherford, there was a a mountain development that went belly up during the bubble burst, but he had been required to post bond for water and sewer on a mountain, basically. He lost the development, unfortunately, and the county ended up taking the money and putting water and sewer on this mountain now where only one person lives. So it's kind of unique, but still the property got what the property was promised through that bond.
That was